FIFRA, and one under state law. Indiana has a pesticide use statute, and that was a other.
What's up, buddy? There. May I,
Message deleted. Next message sent today at 11:57 a.m. Hi, Mr. Berry. This is Lori, one of the nurses at Ascension Statement
Okay, I think
calling and scheduling
did
for coronavirus.
everybody lose me some time ago or just now?
So please call us back.
I unmuted.
1-758-335.
Mr. Berry, you're going to need to mute your microphone.
All right. So how much did we lose, if anything? Let me just kind of resume where I was. You've got obviously our handout with most of this information. So you've got this issue of potential negligence per se under a federal statute and a state statute. And it turns out that it goes to jury trial. And there is issue with respect to instruction on negligence per se. And at the end of the day, the court determines not to use the instruction proffered by the plaintiffs to establish negligence per se. And the issue on appeal was, basically was that reversible error. And the bottom line was that the court said, what is going on here? Okay, sorry. So the court said, no, it wasn't reversible, and it wasn't reversible because the instruction proffered by the plaintiff was basically potentially confusing and may have needed to be supplemented by some other clarifying instruction, but the trial court did not abuse its discretion in refusing that instruction. But in the course of dealing with that instruction issue, the appellate court takes the time to make clear that there have been, over the years, not just the one form of negligence per se that I described before, which is negligence assertion, a common law claim where negligence per se is used to establish a breach of a duty, but there's also negligence per se has been used in the context where the claim is essentially a private right of action under the statute, and the statute is being used not to establish a breach of a duty, but to establish the duty itself. And the court said, we really ought to just use this negligence per se claim on the first one, where it's a common law claim, and that if it's a statutory duty claim, that's not really where we ought to be applying this language of negligence per se. So for future reference, that's how it's divided. If you're going to do an instruction on it, make sure you're clear as to what it is you're doing and make sure that it's not going to confuse the jury. Otherwise, you're not going to have an appealable issue, is the lesson of this case. Moving on, our next case is one that is certainly an issue of first impression. The case is Anonymous Physician 1 versus White, decided by the Court of Appeals on July 29th in an opinion by Judge Pyle. And as we note in the handout, the case involves this unusual situation, a child suing his father for impregnating his mother. And how does that happen? Well, it happens if the father is a physician and the child is born as a result of artificial insemination of the mother. And there's a claim because the physician, in using his own semen, has violated a contract between the mother and the fertility clinic. And so in this instance, we have a mother who goes to the fertility clinic, deals with this physician back in 1981 to become pregnant. She is promised that the sperm that will be used will be in the insemination will come from an anonymous medical school resident and no more than 3 inseminations within a well-defined geographic area. But that's not essentially what happened. which was not learned until 34 years later in 2016, when the child who was born by this process learned that the physician had in fact used his own sperm and used it with much more than 3 such cases. And so suit was brought against the doctor and the fertility clinic, alleging claims for breach of contract, medical malpractice, and negligent hiring and retention. Not surprisingly, a motion was filed to dismiss the complaint for various reasons, that there was no duty owed to Matthew. He wasn't even born at the time. And that he didn't have any compensable injuries. He actually was born and everything seems to be fine. But he did assert that there were emotional distress damages associated with this. And the defendants, upon appeal, said the Court of Appeals should overturn the denial of its motion to dismiss. In ruling on that, the court looked at the contract, looked at the intended beneficiaries, and said, Matthew was an intended beneficiary, including conception, intrauterine development, birth, and life as a human being. All of those were benefits that were expected to be received by this child. And that satisfies the elements for a third-party beneficiary. And for purposes of Rule 12b-6, passed muster. And then the court also looked at whether there was a duty owed for purposes of tort claims. And the court said, basically, well, there's a concern here with accidental incest. And the court allowed that. And although Indiana does not recognize a claim for wrongful life, the court said there may be damages here, basically emotional distress damages, on which he could prevail. And so the court affirmed the denial of the motion to dismiss, finding that a child born with the assistance of a fertility clinic has standing to assert claims for breach of contract as a third-party beneficiary of his parents' contract with the clinic. It is also, I think, interesting to note the language of the court in affirming the denial of the 12b-6 motion expressed a very high bar for a 12b-6 dismissal. Put it in these terms, because it does not appear to a certainty on the face of the complaint that Matthew is not entitled to relief, a dismissal of Matthew's complaint would have been improper. And so when you understand this case, it's just in the context of a 12b-6 motion, and obviously other things may develop later in the litigation process, but it's returned to the trial court. And one of the things that also related to 12b-6 motions, the court noted in a footnote that when evaluating the merits of a 12b-6 motion to dismiss, the court is prohibited from hearing any evidence and may look only to the facts alleged in the complaint. Obviously, if you want to convert the motion to a Rule 56 motion, that's done essentially by offering evidence, but the court is making clear that it's not going to consider any evidence in connection with a 12b-6 motion. So with that, I'm going to turn it over to Brad, if he's still online.
Yeah, the first case I'm going to talk about today is McGowan versus Montez, which is a case from last August in the Court of Appeals by Judge Friedland. And it deals with the Good Samaritan, which the court said it only deals with rarely. And basically this statute immunizes people who are responding to emergencies by providing emergency care. And the situation is this: you had McGowan was driving a semi without a trailer on the back of it one foggy morning on a 2-lane country road in Tippecanoe County. Because of the fog, he was going slowly, and then he saw a heavily damaged pickup truck in a ditch on the side of the road. He also saw a gentleman named Patton walking around the truck, and so McGowan stopped in the middle of the road and did not put his vehicle into park. He just braked and rolled down the window and asked Patton if he was okay, and McGowan offered to call 911. Now, meanwhile, you had a woman named Higgins who was driving the opposite way, saw the semi pulled over, stopped, put on her hazard lights, and she was past the semi when she did that. And then along came Montez, driving in the same direction as McGowan was doing. Now, Higgins saw Montez, flashed her lights at him, but he didn't slow down. And he didn't brake at all before he hit the back of McGowan's semi. And he did that just as Patton was asking McGowan to call 911. And then another vehicle behind Montez saw the semi and was able to stop before there was a collision. Now, McGowan sued Montez for negligence, but then Montez filed a counterclaim against both McGowan and his employer, Vision. Now, McGowan and Vision moved for summary judgment, arguing that they were immune under the Good Samaritan law. And the trial court granted that motion. It went up on appeal. Now, on appeal, the court said that, this law protects those who gratuitously render emergency care. That's the language in the statute. But the statute does not define what emergency care is. Now, Montez argued, McGowan's just a truck driver. He was not actively participating in rendering care or assistance, so he shouldn't be immune. But the court, what it did is to figure out what the legislature meant by emergency care. It looked at the language of the statute and saw that the statute talks about somebody who is covered if they provide medical treatment or if they arrange for further medical treatment or care. And the court said that language was broad enough to protect McGowan. And one thing I noted in the handout is that the court's rationale was that if the legislature wanted to prevent this kind of breadth of application of the Good Samaritan law, then it had the ability to say so in the statute. Now, the court also said that these kinds of immunity statutes are in derogation of the common law and therefore would be strictly construed. And it didn't describe how there was how one of those fit with the other. The case is up on transfer now, and it'd be interesting to see if the Indiana Supreme Court takes that up in order to clarify that particular legal issue for all of us. Now, there's another issue left in the case, because even though McGowan was covered by the Good Samaritan law, he could still be liable if his conduct was grossly negligent or willful and wanton. And basically what the court said is that, when McGowan stopped in the middle of the road, yes, he violated a safety statute, especially since he didn't put on his hazards, he just has brakes on. But the court said that there's not really an issue here as to gross negligence because he checked before he stopped, didn't see anybody. It was a really short duration. And, the fact that he had his hazard lights on was immaterial because he had his brake lights on. The brake lights would have overridden the hazard lights. And the court's point was that when we have a violation of a safety statute, we normally have negligence per se, as Ron mentioned. But a presumption of negligence, the court said, is dissimilar to a presumption of gross negligence. So just because you have negligence per se doesn't mean you are entitled to a presumption that there's gross negligence there. So given all that, the court said that McGowan and his employer were immune. But like I said, it's up on transfer right now. And I'm really interested to see if the Indiana Supreme Court has any interest in dealing with that particular case. The next case I'm going to talk about is Dempsey versus Winsky, which was decided by Judge Bailey. And it comes out of LaPorte County and deals with property tax issues. Dempsey owned land in LaPorte County, and LaPorte County went with in 2008 did a reassessment of the property taxes over the whole county. And if the reassessment showed that you'd paid too much and you'd have a reduced tax bill, then the county would issue a check, but they wouldn't pay any interest on that check. If you were owed money to the county, if you'd underpaid as a result of that reassessment, a credit would be from, if you previously owed taxes and your taxes were too much, a credit would be applied to the delinquency. Again, no interest would be paid. Well, Dempsey sued saying he should have been paid that interest. And the parties did some discovery, and then Dempsey moved for class certification. And in there, he said that, we have about 88,000 different pieces of property here in the county, and that numerous taxpayers will have had their tax bills decreased and would have gotten checks, but wouldn't have gotten any interest, and they would all be class members. And so then they said, but the identification of who those people would be, we can do that after class certification court. Well, the trial court denied the motion, and Dempsey appealed. And on appeal, the court said that Dempsey's way of trying to litigate this case by just saying, surely there's some other class members out there, without putting in the work to identify who those class members are, at least one other class member, made it, quote, difficult, if not impossible, to apply the test of Rule 23, the class action rule, to the case. It said that the statistical probability that with 88,000 parcels of real estate in LaPorte County, someone would surely fall within his proposed class. This court said this is a logical proposition, but it stops short of Dempsey meeting his burden of proof to show that common issues predominate. And it also failed to show that there was that the class action was a superior method of resolving the issues. And it looks like what the court really thought is that Dempsey needed to do the work before moving for class certification, because what the court said was that that while Dempsey said he was willing to strenuously represent anyone who was identified as a class member, he did not accept the invitation to review records in discovery. At bottom, Dempsey's not identified any person he expects to vigorously represent. He simply does not know what taxpayers, if any, have initiated individual litigation or are interested in doing so. With the core deficit of information, Dempsey could not, by bald assertions, meet his burden of showing the class action litigation was superior to the other methods for the fair and efficient adjudication of the controversy. And while not everybody does class actions, this shows that if you do attempt one, you need to act, and you're the plaintiff, you need to actually put the work in before moving that class for class certification, that Indiana's courts aren't going to make it easy on you to gain that kind of leverage in the lawsuit. Ron?
Our next two cases involve issues, I find them very interesting, issues associated with medical malpractice. The first one, Cortez versus Indiana University Health, was decided in July by the Court of Appeals. And the actual causes of action that were sought to be asserted in this case were for fraud, criminal counterfeiting, forgery, violations of the Crime Victims Relief Act, and the tort of outrage. And the issue basically were those claims is you have to go to a medical review panel when those are the claims that you're asserting. It's not your garden variety medical malpractice case, obviously. But here's how it evolved. You have a fellow named Santos Cortez. He went to the IU Health Wound Clinic in 2012, and he consulted at that time with an attorney regarding potential medical malpractice claims. And he filed a claim with a proposed complaint with the Indiana Department of Insurance against IU Health. And after production of records that had turned out to be altered, they settled with IU Health, preserving the right for other claims of the kind that I just described. And then later they filed this separate suit against, I'm not sure quite who it's all against, but still against IU Health, but not for the prior issues. Was still one of the defendants, apparently. So, but IU Health, the defendants here said no, when they sought to sue this in court without having a medical review panel first review it. They said this was one subject to the Medical Malpractice Act, and you've got to go there first with respect to these claims. And they asserted essentially a 12B, not essentially, but what was a 12B1 claim for lack of subject matter jurisdiction. The trial court granted that motion, saying this all arose out of the alteration of medical records. And in 2011, the Indiana Supreme Court, in the case of Howard Regional Health System versus Gordon, had dealt with the question of medical records and specifically an issue of a spoliation claim of action. And they said that fell within the Medical Malpractice Act. And the Court of Appeals here, after considering all of these claims that were asserted, said the gravamen of all of them concerns the alteration of medical records. And in light of what the Supreme Court had decided in the Howard case, that this also fell within the ambit of the Medical Malpractice Act, and the trial court would not have jurisdiction until it went through the medical review panel process. Now, so that's where it stands now. I should mention that the issue is the case. There has been a petition for transfer. It has been fully briefed now for about 3 months. And so how long this is going to stand, yes, I would say will depend on whether that petition for transfer is granted or not, and then how the Supreme Court decides it. There was one other side issue I wanted to mention, and that concerns the fact that Pete Schroeder's firm, Norris, Chaplin, Schroeder, was also named as a plaintiff in that case, having represented the Cortezes in the initial medical malpractice action and incurred expenses and presumably other damages as a result of that. The court said, no, the law firm lacks standing to assert claims against IU Health. The party that has a claim, or the parties, are the Cortezes, not the law firm, for what that's worth. So that's a very interesting case. We'll see what the Supreme Court does with it in terms of how broad the jurisdiction is in the medical review panel process. Does it go as broadly as is asserted here, or is it going to be more narrowly constrained in light of this decision and the court's extension of it from the Howard case? Our next case also arises in the medical malpractice area, and it involves an interesting question of when you assert a claim, file a proposed complaint with the Department of Insurance, and in this instance there was a proposed complaint filed. It did not identify any of the physicians who were allegedly negligent, and that created problems for the hospital. And so in this case of Anonymous Hospital versus Spencer, the issue basically was raised, well, how much specificity is the plaintiff obliged to give with respect to identifying physicians who are potentially comparatively negligent and there may be third-party claims against them. And by the time they get identified in the case, statutes of limitations have expired. And so Mr. Spencer, after being hospitalized, filed his proposed complaint, and the hospital asked the trial court to strike his allegations of vicarious liability and exempt from it any of the conduct of physicians who were not named, because they having not been named, they weren't identified during initial discovery, and the statute of limitations has expired. And the court said, well, the court got involved by reason of a request for preliminary determination while the matter was still before the panel. And the appellate court, when the trial court decided, let me see if I've got this straight now, that the trial court denied the motion to dismiss or to as to any of the vicarious liability claim as to unnamed physicians. The hospital appealed. So the motion of the hospital to dismiss on that basically as an issue of law was denied, and the hospital appealed. So now the issue goes to the Court of Appeals, And first, the Court of Appeals looked at what's the standard of review on this appeal. And this is language that applies to all sorts of cases, and not just this one. But the court was very clear that it was de novo review in this case. And the court said, whereas here, the court neither conducted an evidentiary hearing nor resolved any disputed facts, our appellate review is de novo. It is not abuse of discretion. So that may apply in some other appeals that you've got that you might want to consider beyond the medical malpractice area. But with respect to medical malpractice, the court basically said that this is an informal process, and we are not expected, and the plaintiff is not expected to identify all parties that may be negligent, and it is not expected to identify in detail all of the issues of liability, but to simply assert a general theory of liability. And even if that means that a statute of limitations expires, where they have in the proposed complaint identified this course of treatment in the hospital, that would be sufficient. And the court actually was a little bit critical of the defendants in this case, expressing concern by the hospital's attempt to so severely, and we think unjustifiably, limit Spencer's claims against it before the case has even been presented to the medical review panel. And I thought this language was kind of interesting. It's on page 12 of the handout. The hospital waxes poetic about being prejudicially misled by what it characterizes as a threadbare proposed complaint and bait and switch initial discovery responses. We remind the hospital that, in the words of Karen Carpenter, we've only just begun. Now, I always like it whenever the court brings in lyrics from a song or the name of a song. I've done that a time or two, but it hasn't seemed to be well received when I do it. But you might try it now, at least with Judge Crone. It seems he seems to like that, at least when he explains his own reasoning. And in terms of the characterization of the hospital waxing poetic, I suppose one has to be careful in that regard as well if we wax too poetic ourselves on the other side. So in this case, it's informal, it's initial. The court's not going to hold the plaintiff too strictly, with respect to what's asserted in the proposed complaint under these circumstances. So with that, I'm going to turn it back to Brad.
And the next case I'm going to discuss kind of plays on that same issue. It's Jernigan versus Indiana University Health. And in this situation, you had a Dr. Ritter performed a spinal surgery on Jernigan at IU Health North. And there was an anesthesiologist there named Dr. Miller who participated in the surgery. Well, bad things happened during the surgery, and Jernigan had to be admitted to the ICU. And then so later he files a proposed medical malpractice complaint against Dr. Ritter and IU Health. Now, that proposed complaint identified the wrong anesthesiologist. But the review panel, when it gave its opinion, talked about Dr. Ritter and IU Health, but did not address the conduct of any anesthesiologist. Well, Jernigan then filed a complaint against Dr. Ritter and IU Health and did not name any anesthesiologist. The claims against Dr. Ritter were dismissed, and IU Health moved for summary judgment because Dr. Miller, they said, was an independent contractor. Well, Jernigan asked for 2 different extensions of time to respond to the motion for summary judgment. They were supposed to expire on April 7th. Now, on March 22nd, the parties had a telephonic status conference with the judge where they informed the judge that they had agreed to extend, between the 2 of them, to extend Jernigan's response date to May 8th. So the judge entered a CCS entry, which is there on page 12 of the handout, which said, among other things, that the parties have stipulated to extending deadline on response to the pending motion for summary judgment to May 8th, 2019. And then later on, defendants counsel will circulate an order on the summary judgment deadline. Well, defense counsel didn't do that. But Jernigan waited and filed his response on May 8th, at which point IU Health moved to strike as untimely because Jernigan didn't file an independent motion requesting that extension. The trial court denied the motion to strike, but granted IU's motion for summary judgment and went up on appeal. And the first issue the court dealt with was this motion to timeliness of the response issue. And as we all know, Indiana has a bright line rule that says if you don't move and get an order granting you an extension of time on your summary judgment motion before the deadline, you've missed your deadline. And so the question was, is what Jernigan did here sufficient? And the court said that without specifying exactly what is an appropriate form of a request, that there is a verbal request made here, that request was memorialized in the CCS entry, and that the court's directive to the defendant to circulate an order was meant to separately express what the court had already ordered in its CCS entry. And so the court said to conclude that Jernigan's response was untimely would elevate form over substance, which we declined to do. Now, next, it went to that question of whether Dr. Miller was an independent contractor or not, and therefore whether the failure to name him in the complaint was meant that there wasn't any vicarious liability. Now, the court went through a lot of the law dealing with this, and the Indiana Supreme Court has previously adopted a section of the restatement that to determine the apparent agency of a hospital setting. And that restatement section focuses on the reasonableness of the patient's belief that the hospital or its employees were rendering health care. Now, IU said that when Jernigan checked in, he was given a copy of Dr. Miller's card. Dr. Miller's card showed that he worked for this anesthesiology group and not for the hospital. And therefore, that should have been sufficient when he was given this business card to check in. What the court said is that we cannot conclude that a sole business card handed without more to an undoubtedly already anxious surgical patient at check-in conclusively affirms that Dr. Miller was not an employee of IU Health or that the practice group is his employer. Indeed, the record reflects that Dr. Miller himself rejected the label of employee and pointed out he was a partner in the practice group. As such, the business card merely indicates an affinity relationship, but does not more closely specify or define that relationship. So, that would meant that there was a genuine issue of fact as to whether Jernigan should have known that when Dr. Miller was being the anesthesiologist, or any anesthesiologist being the anesthesiologist, that they were an employee of somebody other than the hospital. And so that what is going to go back to the trial court for the parties to decide that factual issue to see if the hospital has vicarious liability. Now, Ron mentioned standing in an earlier case, and this next case, Indiana Family Institute, Inc. versus City of Carmel, is all about standing. And as I wrote in the handout, we've heard a lot about standing in the 2020 presidential election and various federal courts. But this case shows that Indiana courts also really care about standing. And the situation was that in 2015, Indiana passed its Religious Freedom Restoration Act, RFRA. And among other things, that statute has various anti-discrimination safeguards, including based on sexual orientation. And then some cities around Indiana have passed local ordinances which bar discrimination on the basis of sexual orientation. We had some Christian advocacy groups who believe that RFRA and these ordinances infringe on their right to freely exercise their religion and speak because they can't preclude same-sex couples from coming to their events. These statutes and ordinances have certain exceptions and exemptions. These companies don't think they fall within them, and so they filed a complaint seeking declarative and injunctive relief. And they moved for summary judgment from a cross motion from the cities. And the city said there was no standing. The trial court agreed and the companies appealed. And so the court began its analysis by talking about standing and saying how it's a significant restraint on the ability of courts to act, and that it prevents it prevents academic debate or abstract speculation about what the law is or should be. And so there's a three-part test to have standing. You have to have an injury in fact, a causal connection between the injury and what you're complaining about, and a likelihood that the court can actually redress the injury with a decision. And the problem that the companies had is that they didn't have any policies of excluding same-sex couples, and had not actually ever excluded anybody. And they didn't have any indication that any of these cities were going to be enforcing their ordinances against these advocacy groups. And so the court found that these companies were free, without interference, to express their religious views on marriage and human sexuality as they always have. And so without that kind of a showing of actual fear that their exercise of the rights would be chilled, they had no standing. Now, the companies had a fallback position, something called public standing. And this is when somebody may not have individual standing, but is suing and has public standing to enforce a public rather than a private right. And the court gave some examples of when that had been applied, dealing with whether a public contract was authorized, whether a statute was constitutional, whether apportionment of senators' representatives was proper, those kinds of things. And it said that what you have here is not that same kind of thing, because the standing elements don't foreclose a challenge to RFRA by anyone. Instead, somebody who has been notified that they violated it, or would have their rights substantially burdened by an imminent threat of enforcement, would have standing, and so there's no public standing that's possible. And the last case I'll talk about before I kick it back to Ron, it deals with another constitutional issue. In this case, it's notice and due process in tax sale cases. You had a gentleman named, this is from the Indiana Supreme Court, by the way, Indiana Land Trust Company versus XL Investment Properties, LLC. You had a gentleman named Delaportas who owns Midwest Investment, Inc. He bought about 140 acres in Michigan City in the early 90s, developed that property for commercial uses, but one lot on that property, lot 2, was undeveloped. He transferred the property to Trust 4340 in 1993, and the deed for transfer said that the notices for the tax bills should be sent to Midwest, and gave an address on LaSalle Drive in Chicago. Well, over the years, Midwest moved numerous times, didn't notify the auditor of this, and eventually it landed on Clark Street in Chicago in 2016. Now, Midwest kept the property taxes up to date through 2008, but didn't pay any property taxes from 2009 to 2015. So there's a tax liability of over $230,000. Now, during this period of time, an adjacent lot was in the same trust, underwent a tax sale and was redeemed. And so Midwest updated its address with the auditor on this other property, but the records for lot 2 were not updated. Well, another thing that happened was that the auditor hired a company named SRI to prepare its tax notices. And the contract said that the auditor would agree to search its records for a better address if notices were not successfully delivered. So with that background, you had this SRI company send out its notices about a tax sale on lot 2 via first class and certified mail. Now, the first class mail was not returned. The certified mail was as undeliverable. And so SRI performed a skip trace, not successful. Auditor didn't bother searching its internal records to see if it had a better address. Property went to tax sale, was sold to XL Investment. Now, XL Investment filed a quiet title action. At this point, they found the registered agent for the trust, and the trust said, hold on a minute, let's move to set aside this tax sale because we didn't get proper notice. The trial court denied that motion. Court of Appeals reversed, and then it went up on transfer. And on transfer, the court's decision was largely guided by a case from the U.S. Supreme Court, 2006 case named Jones versus Flowers. And the court basically said there's several what it called foundational observations and key lessons that it took from this Jones case. That first, that due process requires a notice that is reasonably calculated to apprise the interested parties of the action and give them an opportunity to object. Second, while actual notice is not required, that the government must take additional reasonable steps, if practical, when notice via certified mail is returned. Third, that in order to assess the constitutional adequacy, there's a balancing of interests between the interest of the state and the interest of the individual. And so the court said that it framed the question with those questions in mind as to whether the auditor acted or failed to act as one desirous of actually informing the trust of the impending tax sale. And it said the auditor met this test because the statute requires that notice be sent versus first-class mail and certified mail. But it says the statute says the auditor only needs to take additional steps if both notices are returned. Now, the taxpayer said that, well, hold on, you had the notice that was returned saying that it was not deliverable as addressed, unable to forward, and for the certified mail. And so we should just assume that this first-class mail, I mean, it wouldn't have been able to be delivered either because it was not deliverable as addressed, unable to forward. And the court said, you know what? We disagree. That's taking speculation a bit too far. And I'm going to quote the court here. The first-class mail in this case was sent contemporaneously with the certified letter. One could reasonably assume the unreturned first-class mail in this case indicated to the auditor that the mail was received by the intended recipient. We do not think that under these circumstances, the auditor was required to speculate any further. So although the auditor received back the certified mail as undelivered, and although the auditor had a contractual obligation with SRI to search its own records if that was sent back as undelivered, there was actually no requirement that the auditor do that the taxpayer could enforce. And so sending it out via the first class and certified mail and having the first class never be returned was sufficient for due process purposes. Ron?
Our next case involves an interesting issue of sports law as applied in Indiana. It's the case of In Re CG, decided on September 29th with the decision by Judge Tavitas, and involves this situation. Well, first of all, you start with the premise, well established in Indiana law, that generally when someone is hurt in a sport by another sports participant engaged in ordinary conduct of the sport, there's no liability. In this instance, it's a coach that's involved. There's a high school coach, a freshman basketball player, CG. They're doing layup drills, and the coach is defending against the layups, swats the ball away. It hits CG, and she suffers a concussion, and she sues. And so the issue then becomes, well, it's not, is this coach a sports participant under these circumstances? Coaches generally aren't thought of as sports participants, but Court of Appeals makes relatively short work of it, basically saying yes. In these circumstances where you're having a drill and the coach is essentially acting as a player or participant defending a layup, that's an ordinary part of the game, and in the absence of either intentionally causing injury, which wasn't an issue here, or recklessly causing an injury, this is not going to be conduct that would be compensable in a court of law in Indiana. So it's if you ever are dealing with sports law issues at all, this is one that you might just want to look at and remind you of the general rule, and now it's clearly going to apply the concept of sport participant to a coach who is behaving essentially as a sport participant. He's not, or she's not excluded. This was Molly A. Moore was the coach, or Holly. Hannah A. Moore was the coach. So anyway, that's that case. Let's move on now to the case of Warsaw Orthopedic Inc. versus Sasso. And this is a case that you may have heard about, where a $112 million jury verdict was given in November of 2018 after a 3-week trial up in Marshall County. The case was brought by Dr. Rick Sasso against Medtronic and some other entities, essentially for breach of contracts. Dr. Sasso had a deal with Medtronic where he gave them certain intellectual property rights, including patents, and was promised royalties in return. And he claimed in this lawsuit that he was not receiving all the royalties that he thought were owed. And there were two main contracts at issue, one a screw agreement, that's what it's called in the opinion, and another called a vertex agreement. And there were a number of issues, and I won't go into them in detail. Actually, the decision, it's a 45-page decision involving a $112 million verdict, addressing a lot of issues, and is issued as a memorandum opinion, not for publication. How long it'll stay that way, I don't know. It's certainly going to have a petition for transfer. But there were two issues that I thought I would bring to your attention. The first dealt with the issue of contract modification. The contracts in question included a term that said the contracts can only be modified if in writing. But the argument was made by Sasso that if there had been a course of conduct that effected a modification of the contract. And specifically, the contract had said that the parts that would be covered by this royalty promise needed to be listed on Schedule B. And there were no such parts ever listed on Schedule B. But for 16 years, Medtronic paid Dr. Sasso for the things that it thought was fit within it. And the court basically said, you can, by course of conduct, modify a contract even when it says it can only be modified in writing. And this course of conduct was sufficient to do that. Now, let me caution you that with respect to that ruling, the court looked to precedent under Tennessee law because the contract said Tennessee law applied. But in looking at the prior cases in Indiana, it seems like the same principle would apply under Indiana law. The other issue that I thought I'd bring to your attention is the claim that this award was wildly inflated and was excessive. And the court said, well, look, juries determine damages. If there's evidence supporting it, then that's sufficient. And here, Dr. Sasso had an expert who identified to the dollar exactly what was awarded by the jury as damages incurred by Sasso, and specifically associated with the royalties that he was entitled to. That's what the jury awarded. And the notion that this was wildly inflated, the court said, Indiana law, in Indiana, we employ an extremely deferential standard when reviewing a jury's damage award, extremely deferential. And they were deferential here. And they were deferential, among other reasons, because there were lots of reasons why Medtronic didn't think this expert's opinions were good ones. And they raised them on a Daubert motion seeking to exclude the testimony, but they failed. It was denied on a Daubert motion. When the expert testified at trial, Medtronic's lawyers did not object. And failing to object, even though you've litigated on a Daubert motion or a motion in limine, you have to object at trial. In this case, the court held that objection was waived because it wasn't made contemporaneously with the admission into evidence. And with that, I'll turn it back to Brad.
The next case I'm going to talk about is Perkins versus Filio. And for those who are avid followers of us, you may remember that we talked about this case before in from a prior appeal. It involves a woman who broke her wrist after getting headbutted by a ram at somebody else's farm. Basically, Filio owns a farm where she keeps animals, including sheep. But in August 2016, she was spending some time in Florida and asked Slate to feed and water the animals at her home. Now, a female goat fell ill, and Slate couldn't get a hold of Filio. So he asked his sister-in-law, Perkins, who had more experience with farm animals, to come over and help out. Well, Perkins saw that the goat was in the pen with a sheep, and the sheep didn't have any horns, but unbeknownst to Perkins, the sheep was a ram, who when she climbed into the pen and put her back to, headbutted her from behind, knocking her to the ground and breaking her wrist. Perkins sued Filio. Filio moved for summary judgment, saying the ram wasn't a dangerous animal. That was the one we talked about before. Went up on appeal. The Court of Appeals said there are genuine issues fact on the issue. So went back down, tried to a jury. And there were the question in this case were all about the jury instructions. Perkins wanted to use one model instruction. Filio wanted to use another. The trial court used Filio's version. And Filio also wanted an instruction on maintaining a proper lookout. Perkins objected to that. Trial court gave it. Jury returned the defense verdict. On appeal, there was this dispute about the instructions and what kind of instruction you should give regarding an invitee on somebody's property when there's a dangerous animal there. And Filio's instruction had 3 different elements to it. Perkins' instruction had 4. They're both based on model instructions. But the court said it really didn't matter which one the trial court gave in this case, because there was not a meaningful difference between the instructions in the context of this case. And basically what it said that Perkins' instruction adds 2 elements not present in the one that Filio gave. The defendant knew that the condition existed and created a danger to invitees. And 2, that the defendant should have recognized invitees would not protect themselves from the danger. But the court said to hold the defendant liable, you'd have to show under Filio's instructions, you'd still have to show that the defendant knew that a particular animal had a propensity for violence, or that they were part of a class of animals that had dangerous propensities. And basically, given these various kinds of instructions, without that meaningful difference, that without a practical difference, it doesn't matter. So the trial court didn't abuse its discretion by giving whichever instruction it gave. And then I went to the issue of this lookout instruction. Now, the lookout instruction normally is in the motor vehicle context. That's where it arose. When you're driving a good car, you got to keep a lookout for everything else that's going on around you. But the court said that it didn't think the lookout instruction should be limited to those kinds of circumstances, and that it could apply here. Just as a pedestrian should anticipate that cars may be traveling down a road, a person entering an animal pen should anticipate that the animals in the pen may behave aggressively towards an unfamiliar presence. And so failing to keep a lookout was an issue. Trial court properly instructed the jury on it, and there is no basis for a reversal. My last case before I hand off to Ron is Kelly versus Kelly. I'm just going to quickly summarize this. You had a gentleman who was married and then got divorced. His wife died. Her dad was investigating the death, suspected the ex-husband. He asked Verizon, he sent a subpoena to Verizon for the husband's cell phone records. Husband says, no, you can't get that. Hires a lawyer to enter an appearance to move to quash the subpoena, but the lawyer didn't file a motion to intervene. Eventually, the trial court found the issue moot, but wouldn't refuse to award sanctions to husband. So husband appeals, and the husband says, no. If you're not a party to the lawsuit, you can't quash anything unless you intervene. And frankly, you can't appeal a decision unless you have intervened. The husband says, hey, I have standing. I'm hurt by this. And the court says, that doesn't matter. You're not a party, so you can't appeal. Therefore, appeal dismissed. And before Ron gets the last case and talks to everybody, I wish everybody a much happier and more social 2021 than we had in 2020. Ron?
Our last case involves the question of whether the quasi-judicial immunity extends to a group called the Athletic Trainers Certification Board when they suspend the license of an athletic trainer. This board consists of 4 athletic trainers and a doctor, and they had suspended Molly Melton from her license as an athletic trainer for misconduct, sexual relationship with an 18-year-old when she was 23. And They basically, was the board protected by this quasi-judicial immunity for the conduct? The bottom line is the court says yes. When you look at the standard for quasi-judicial immunity, this board qualifies, and in suspending the license of the athletic trainer, they are protected, and the claim in this case, Melton versus Indiana Athletic Trainers Board, the claims are precluded. The Section 1983 claims for violation of constitutional rights are precluded by that immunity. We also provide to you our usual tip of the month. I give it to you, the simple one of humanize yourself, with specific guidance from Charla Aldis, a trial lawyer down in Texas who's had remarkable success in a variety of jury trials, and emphasized recently at an ITLA annual meeting about the need to humanize yourself when you're at trial. Don't act like a lawyer, act like a normal human being. And I thought the statement of, when she asked the jury, how many of you think it's none of my business to ask these questions? And the way she says it, and speaks like a normal human being, talks about, it's only fair that you know something about me. I came from a small town, I'm divorced, I have two kids. She's suggesting specific ways to get on the same wavelength as your jury. With that, we are over time. Thank you all again for joining us. And I join in with Brad in saying and wishing you all a happy holiday. And let's hope 2021 is a lot better than 2020, and that we are back to jury trials sooner rather than later. Thank you. I don't know whether Peter